L'audience est reprise.
The court is back in session. I shall resume with the chapter on persecution. I'll say straight away that there's no diverging view in this respect with the rest of the bench, because we are in full agreement on this matter. Article 5 of the statute, Crimes Against Humanity, specifies the jurisdiction of the tribunal in cases of armed conflict, whether international or internal in character, and directed against any civilian population: murder, extermination, enslavement, deportation, imprisonment, torture, rape, persecutions on political, racial, and religious grounds, and lastly, other inhumane acts. In my view, the authors of Article 5 have, in matters of crimes against humanity, established a grading scale in the gravity of crimes, ranging from the most serious crimes against murder, down to inhumane acts, and with just before the last rung of the ladder, persecution. Why is there such a grading scale? Undoubtedly, cases A and B refer to the physical elimination of a civilian populations. The other cases from C to I refer to acts against a civilian population without them leading to death. In any event, each of these offenses can be punished by a maximum penalty. Therefore, there is, within this grading scale, no distinction to be made because of a lesser or greater gravity. Therefore, I am of the view that persecutions on political, racial, and religious grounds are as serious as murder, extermination, or enslavement. Whilst this is a hotly debated issue among the ICTY judges or in the legal academic community as to whether persecutions are as serious as a murder, for indeed a civilian population may be persecuted for acts such as discrimination in hiring without any individual running any physical risk. However, persecutions through speeches, utterances, and writings can be the trigger or even the fuel for murder. A. Persecution. What is the applicable law? This has already been developed in the majority decision read out yesterday, but I want to deal at length with specific issues. The issue of hate speech with regard to the crime of persecution as a crime against humanity was raised in the ICTY, in the Cordage and Cherkis case, and in the ICTR, in the Nahimana et al. Case. In the Cordage and Cherkis case, the trial chamber found in paragraph 209 that the indictment against Dario Cordage is the first in the history of the International Tribunal to allege incitement to hate or encouraging and promoting hatred as a crime against humanity. But the trial chamber had found that the act, as alleged in the indictment, did not constitute by itself persecution as a crime against humanity, because it was of the view that it is not enumerated as a crime elsewhere in the statute, but most importantly, it does not rise to the same level of gravity as the other acts enumerated in Article 5. The trial chamber added that international customary law does not view this act as a crime, and it would be a violation of the principle of legality to convict the accused for an act under the count of persecution. the legal analysis carried out by the trial chamber referred to a footnote 272, to the Šešelj case, and said that the IMT had convicted the accused for persecution because it had incited the German people to active persecution. The IMT found that the acts of the accused, the publication of a virulently anti-Semitic journal, was amounted to incitement to murder and extermination. Šešelj case, IMT judgment, pages 321 to 324. Equally, in the acquittal judgment, paragraphs 672 to 675, the ICTY found the accused guilty for direct and public incitement to genocide under Article 23C of the ICTY statute.
In the Nahimana case, the appeals chamber noted in paragraph 979 of the appeals judgment of November 28, 2007, that the submissions of the parties, notably the submission of the amicus curiae, showed that the interpretation of the Šešelj case provided by the trial chamber was wrong because, and I quote, Šešelj was not found guilty of persecution for anti-Semitic writings that significantly predated the extermination of Jews in the 1940s, but for prompting to murder and extermination at the time when Jews in the East were being killed under the most horrible conditions. And it further said, and I quote again, that this interpretation of the Šešelj case is confirmed by the fact that the IMT acquitted Hans Fritzsche on grounds that his hate speeches did not seek to incite the Germans to commit atrocities against the conquered people. The appeals chamber, for its part, considered that the crime of persecution consists of an act or an omission which discriminates in fact and which denies or infringes upon a fundamental right laid down in international customary or treaty law, the actus reus of the crime, and was carried out deliberately with the intention to discriminate on one of the listed grounds, specifically race, religion, or politics, the mens rea, or of the crime. This is in paragraph 985 of the Nahimana appeals judgment, and it adds, however, not every act of discrimination will constitute the crime of persecution. The underlying acts of persecution, whether considered in isolation or in conjunction with other acts, must be of a gravity equal to the crimes listed under Article 3 of the statute. Furthermore, it says that it is not necessary that these underlying acts of persecution amount to crimes in international law. On paragraph 986 and 987, the appeals chamber goes even further in its analysis, setting there in a very clear fashion once and for all the case law, saying that it considers, and I quote, and I will read slowly because this is jurisprudence, a hate speech targeting a population on the basis of ethnicity or any other discriminatory ground violates the right to respect for human dignity. See, for the Universal Declaration of the Human Rights. Of the members of the targeted groups, harassment, and is thus a discrimination, a de facto discrimination. In addition, the appeals chamber is of the view that speech inciting to violence against the population on the basis of ethnicity or any other discriminatory ground violates the right to security of the members of the targeted group and therefore constitutes actual discrimination. See Article 3 of the Universal Declaration on Human Rights. However, the appeals chamber is not satisfied that hate speech alone can amount to a violation of the rights to life, freedom, and physical integrity. Thus, other peoples need to intervene before such violations can occur. A speech cannot in itself directly kill members of a group, imprison, or physically injure them. Finally, regarding the following question: whether the violation of fundamental rights, right to respect for human dignity, right to security, is as serious as in the case of the other crimes against humanity enumerated in Article 3 of the statute. The appeals chamber is of the view that it is not necessary to decide here whether in themselves mere hate speeches not inciting violence against the members of a group are of a level of gravity equivalent to that for other crimes against humanity. According to it, it is not necessary that every individual act underlying the crime of persecution should be of a gravity corresponding to other crimes against humanity. Underlying acts of persecution can be considered together. It is the cumulative effect of all the underlying acts of the crime of persecution which must reach a level of gravity equivalent to that for other crimes against humanity. Furthermore, the context in which these underlying acts take place is particularly important for the purpose of assessing their gravity. What can I conclude? Well, as far as I'm concerned, I agree with the analysis of the appeals chamber, which invites judges, when they have to make a ruling on the existence of a persecution, to review the case in a holistic fashion, drawing their attention to the underlying acts whose cumulative effect could lead to a certain gravity that would make it possible for any reasonable judge to conclude that there was indeed persecution. But as far as I'm concerned, this can only be done during final deliberations. Therefore, at this stage of the proceedings, I will not review each underlying act, nor will I assess the entire act in a cumulative fashion as indicated by the appeals chamber. At this stage of the proceedings, I will just keep, as underlined by the appeals chamber, that discriminatory, I will only keep discriminatory intent as unlawful ground. This being said, I will now scrutinize and review all the evidence provided by the prosecution to determine whether there has been discriminatory intent. To do so, I will use a year-to-year approach, year-by-year approach. I will take into account all interviews and statements made by Mr. Šešelj in 1990, 91, 92, 93, and I will also mention two of these that are not dated. Thanks to this technique, I will be able to come up with a very clear picture. A number of these elements have already been mentioned in the majority decision, but what's interesting here is to set them back in their time frame. I was able to backtrack to June 25, 1990. During an interview, on that day, during an interview with a journalist from Večernji List, Mr. Šešelj says that the Croats hate the Serbs and that they have megalomaniac ambitions. He adds that hatred is only born to newly created nations. That's Exhibit P 1169. A few months later, during an interview to TV Studio B, November 1st, 1990, the accused declares that he is genetically and ethnically Serb. Exhibit P 1172. 1 month later, during an interview with a journalist called Miroslav Peranovic in a Bosnian weekly on December 1st, 1990, the accused declared that the Ustashi movement, so he's now talking about the Ustashi, is a typically fascist movement responsible for having committed a genocide against the Serbian people. Furthermore, according to him, Croatia is a totalitarian state. P 1173. And he also advocates the banning of all universities using Shqiptar language. A few days later, during an interview with TV Belgrade on December 6, 1990, he says, except for a very few, Croats are all criminals and should be punished through the loss of hundreds of their territories. P32. Furthermore, he uses the word Ustashi several times. Let's now move on to 1991 at the in the Parliament. On February 23, 1991, he takes the floor, P1255, and says, "We're prepared for a bloodbath." During a speech on television on the network TV Politica on April 5th, 1991, Mr. Šešelj says that Croats are trying to use the Muslims to pitch them against the Serbs. He says that the creation of a unified Serbian state will make it possible for the Serbian people to have 1 million enemies less. And he also says that the Serbs are making one of their biggest mistakes when thinking that Croats are their equals. On May 1st, 1991, in an interview with TV Novi Sad, the accused explains that the revenge of the Serbs against the Croats will result or involves the murder of Croatian civilians, and that he cannot prevent it. And similarly, according to him, the Serbs cannot be held responsible for this, since, according to him, this revenge is fully justified. P. 1177. Then we have a video sequence, P. 1003. I almost wanted to show this video, but I think we're running out of time. It's dated May 6, 1991, and this is what he says. To our enemies, which once again are placing the Ustashi knife under the Serbian throat, we say that we are going to avenge today's victims, but that we are also going to settle old scores. And during a TV interview with TV Novi Sad 5 days later, on May 11th, the accused is ironic in saying that whenever a Chetnik is aiming for a Croat in the head, the Thompson rifles are so effective that their eyes pop out of their orbits. P. 1254. Then, on May 24, 1901, this is what he says in the news magazine ON. He says, how can you negotiate with Ustasha? Can't you see that today the entire Croatian people is Ustashas, except for a very few, P. 34. You know, retaliation results in blind revenge. There will be innocent victims. But what else can be done? The Croats better think twice before doing anything. If they become loyal citizens of Serbia, they will benefit of all rights and freedom of citizens enjoy. But in the contrary, they'll have to pack and leave. Then on June 1st, 1991, TV Novi Sad. This is what he says. He seems to boast for having shed Ustashi blood in Slavonia. P. 1180. Then, during an electoral speech on June 4th, 1991, and this was published in magazine Horvats Ustasha Fantasmagorias. This is what he says. If the Croats use you again, the revenge of the Serbs will be terrible, and you will end up way beyond Anatolia, P35. The Croats are arming themselves. The new Ustasha leader, Tudjman, today has 80,000 Ustasha commandos armed to the teeth. We told the Croats, if you ever engage into a new genocide against the Serbian people, we will not just avenge each victim. We will use this opportunity to settle old scores in the name of all victims of the two world wars. As we see, he's been talking twice about settling scores. Then during a TV interview with Novi Sad on July 25, 1991, the accused says that by nature, Croats are cowards. And send mercenaries rather than armed forces in order to defend their interests. He adds that, according to him, Croats are genetically scared and accuses them of being a criminal people. This is Exhibit P 1181. During an interview with a reporter from Duga, a Serbian bi-monthly, on September 13, 1991, the accused suggests that there should be borders, P 1182. And he also says, and I quote, genetically, Croats are cowards. As he said earlier in Exhibit P34. I would ask our usher to please place on the Elmo P34. And P1182. Or, well, let me ask the court registrar to do this.
Voilà, alors vous voyez.
It's done. You have P34 and P1182 in English and also in Mr. Šešelj's language. I continue. Speech made before the Parliament of the Republic of Serbia on September 26, 1991. And there, he calls for the setting up of a temporary Yugoslav government capable, if need be, of setting up a military junta so as to frighten the entire world with these changes. The same session on September 27, 1991, he urges the Parliament to oppose any measure that would result in Serbs living with Croats and Slovenes. P 1258. Here, I believe that we need to have another document on the Elmo. Very relevant. It's an interview with a journalist of Ratni Novine, dated November 24, 1991. Here, the accused declares that Slovenes are thieves who always deceived the Serbs when these two people cohabitated. But you have it here in English. You have it in English and in the language spoken by the accused. Now let's move to 1992. This is an interview with TV Studio B, April 8, 1992. Here, the accused states that he's never in his entire life met a good Croat. And he says that Croats are the Serbs' worst enemies. P1195. April 21st, 1992, interview with the Serbian daily Unity. Here, the accused is calling on state radios to dismiss all Macedonian, Bulgarian, and Croat workers because, allegedly, they run against the interest of the Serbian people. P1197. A few months later, on June 12, 1992, interview with TV Politica, and there he says that there is no good Croat, neither in Imotsky nor in the entire Western Herzegovina. P1201. Now let's move to 1993. And here I am using a press conference which is mentioned in one of Mr. Šešelj's books called The Chief of the General Staff on His Knees. Here he says that the SRS has 16 CC-22 rockets, and he threatens to launch them on the Italian civil population should Italy decide to intervene on Serbian land. P1219. I don't know what Italy had to do here, but this is something he said. Then during an interview with a reporter of the weekly NIN just 1 week later, May 21st, 1993, the accused says that the worst enemies of the Muslims are the Croats. And here it sounds like fueling hatred. So after I checked all this, but I found two that have no date, but I will still quote them: P1264, P1338, P255, and P256.
Mr. President, you quoted a statement of mine, and you said that the Croats are the greatest enemies of Muslims. This is how it was translated to me in the Serbian, and this could very well correspond to my words. However, in the translation into English, he says that the Muslims are the worst enemies of the Croats. So it's vice versa. The Muslims are the worst enemies of the Croats. But this keeps happening all the time. I took all of the transcripts to check them in French and in English, and there are about 4,000 mistakes of this nature.
Very well. I'm very happy because you seem to understand French and English very well, and on the other hand, you never want to read any documents in French and English, so I'm very happy to hear this. Judge Antonetti, thank you for having noted this. I hadn't seen this. I was just reading my document and looking at you sometimes.
Mrs. Latanzi, I can find my way around in Italian as well, because I used to study Latin, and this is how I freshen up my Italian.
La correction a été faite.
The transcript has been corrected. This has to be accurate. I know that Mr. Šešelj checks everything, and I must not make a mistake. and I endeavour not to make one.
Ça peut venir du fait que je lis trop.
This may come from the fact that I read too fast, I don't know.
Il aurait dit dans ces documents non datés.
Purportedly said in those undocumented, unnumbered documents that no crime will remain unpunished, and a sentence which is noteworthy. Let me quote: hordes of Ustashas have swept over our villages, are pouncing on our women and our children, and are trying to put an end to the genocide undertaken against the Serbian people. P62. In the Oberschall report, everyone remembers that the prosecution called Mr. Oberschall as a prosecution witness for him to testify on the nationalist propaganda of the accused in the 1990s, from 1990 to 1994. The expert on pages 18, 22, and 24 of his report, namely mentions persecutions, and on pages 9 and following analyzes the speeches on the deportation of the population. Now, to be fair, it is important to remember that on a decision handed down on the 30th of November 2007, the trial chamber dismissed the expert capacity of this witness, but nonetheless admitted, for practical reasons, his report in its decision of the 24th of January 2008. The chamber will consider the fact that this expert was rejected as an expert to assess the probative value of this piece of evidence, P5. During the testimony of this expert, videos were shown, and a number of these videos proved to be particularly relevant as far as persecution is concerned. In video P14, for instance, if we had time, we would show it, but we don't have time. This is a speech given by the accused in Jagodnac in April 1991. The accused mentions General Tudjman and the new Ustasha authorities, who, according to him, once again held a gun to the head of the Serbian people. And they were once again trying to provoke another genocide. He then declares each Serbian life will be avenged. On a speech delivered on the 13th of May 1993 as part of a visit by the SRS leaders in Banja Luka, P18 stated, the next time they strike, they, the Muslims and the Croat, must be killed so that they never stand up again and that they never strike us again. I shall now more specifically look into the speeches delivered at Hertkovci. Paragraph 125 of the pretrial brief considers the statements made by witnesses VS 26 and VS 1133. According to the prosecution, these witnesses were telling the truth.
Je mets un bémol en disant ceci. Toutefois, je me dois.
However, I must remark that witness VS 26 ascertains, and he is in total contradiction with the speech delivered by the accused, in which he said that he would gouge out the eyes of the non-Serbs, of the Croats and the Hungarians in Subotica with rusty spoons and forks. This does not figure in the speech in question. This same witness said that the accused met leaders of the SRS and the SUPA, and that on that occasion he purportedly called for the deportation and murder of non-Serbs. The witness VS26, who did not testify for medical reasons, as everybody knows, did, however, testify in the Milosevic case, but changed his statement afterwards and wished, despite his poor state of health, to be a defense witness, and stated this on several occasions. Accordingly, as things stand, a reasonable trier of fact cannot accord any credit whatsoever if the statements of this witness are not corroborated by another witness, who would then not be challenged. The allegations of witness VS 1033, according to which the accused Šešelj purportedly said, let me quote, mixed marriages between Serbs and Croats must be purged, and the children born of this union must be killed. And he purportedly quoted the personalities or figureheads that were non-Serbs that should keep Herkovci. This has absolutely not been confirmed by the speech which the chamber has received. In paragraph 127 of the pretrial brief, the prosecution holds that the accused delivered a speech on the 6th of May 1990 in Herkovci, and before the speech was given, music was broadcast, and 2 hours before his arrival, volunteers of the SIS and the SCP arrived by bus, wearing black uniforms and armed with guns. When this speech was given, and I have read this speech over and over again, 10 times perhaps, in order not to make a mistake, one of the speakers quoted the names of non-Serbs who had left Herkovci. And contrary to the prosecution's allegations, it was not the accused who had quoted the names of these people. All you need to do is look at the documents which the prosecution has. According to the prosecution, following this speech, some Croats decided to leave Herkovci, relying on VS 1136, and according to witness VS 1134, an overall harassment and intimidation campaign had been directed against the non-Serbs, and more specifically against the Croats in Herkovci. These were constantly subjected to threats over the telephone or direct threats. Admittedly, the accused did say that no crime would remain unpunished and that people responsible would be taken to task. These words were uttered in a situation of heightened tension, and are mirror words uttered by democratic states nowadays in the event of terrorist attacks, for instance. As the evidence stands, and on reviewing the indictment, the trial brief, the exhibits, and the witness statements, I can qualify these utterances, interviews, and statements of the accused along the lines of speeches that are likely to be qualified as hate speech and containing a discriminatory ground.
Voici